Hello, everyone. In life, we are often told to focus on the little things. This is true with estate planning as well. Today, I will talk about why. I'm Raluca. I offer estate planning, family law, and immigration services to my clients. And I'm here with my office and marketing manager, Nina Clear. Thank you for your likes, shares, and comments. We really appreciate your support.
So explain to us what you mean by the little things, please.
Sure. It may help to break it down. In estate planning, there are different types of property, tangible and intangible. Intangible are things you cannot touch, like a bank account or real estate. Tangible property includes things you can touch, like your dad's dog tags or your mom's tea set she always promised you that you could have when you were a child because you loved it so much. So tangible items are what we could call the little things.
So we've talked about this before, but if you write in your will, all my personal belongings go to this person, that person doesn't have to give anyone else the tea set that you loved and were promised.
That's right. So if you want to give someone specific gifts, it is helpful to include a list of tangible items you want to give to specific people in your will.
So you still need a will to give someone these items?
Yes. As we talked previously, Georgia requires a signed written document witnessed by at least two people who are not beneficiaries.
And that's if you want them to have it after you die. If you want to give it to them when you're alive, you don't need anything.
Of course, yes.
Okay, and remind me, please, does the will need to be notarized?
It is not required to be notarized. However, if you want it to be self-proving, which can speed up the processing of it, that is required.
You do have to have a list in your will, though, of those little things?
You can, or you can add a page, which in some states, but not in Georgia, is called a Personal Property Memorandum. In Georgia, if you don't list the item specifically in the body of the will, it is called a codicil, which means an amendment to your will. If your will would say all my tangible property is listed in the attached codicil, then that's going to be attached, and you have to have it attached to your will.
So it's not separate from your will?
Not really. It is part of the will, but a codicil allows you to change who gets what, or if your property changes, you can update it. It is easier to update that than redoing your entire will. Perhaps you might want to keep the majority of it the same, but only want to change a few items, so I would recommend a codicil.
Do you need an attorney to do that?
I always recommend that you have your estate planning documents reviewed yearly by an attorney.
And why is that?
This ensures that the language in the will complies with the existing state law where you are. Sometimes the legislature changes what needs to be in the documents, and if your document is not updated, it may no longer be valid.
If you have it reviewed yearly, do you need to have the attorney update the codicil regarding your personal property?
No, you can change that yourself, but it does need to be signed, witnessed, and dated each time it is updated, just as required by the laws for wills in Georgia. Many sites will tell you that this memorandum does not need to be signed or witnessed, but that is not true in Georgia.
What happens if it isn't signed and witnessed as required?
It won't be considered part of the will, and your belongings may not be distributed as you want it. So that's another reason it's a good idea to consult an attorney. Online sites may tell you to do something that seems very reasonable that doesn't comply with the laws in your state. So thank you so much for watching today, and we'll see you tomorrow. Bye-bye.